You walk into family court thinking justice is a set of balanced scales. Lady Justice blindfolded, weighing facts alone. But the moment the hearing starts, you feel the floor tilt. Your ex's lawyer opens with a serene smile, painting her as the daily caregiver who keeps the household running while you focus on work. The judge nods. Suddenly, the bigger paycheck that paid every bill becomes a strike against you. Proof you can afford higher support. Proof you chose career over caretaking. You glance at your attorney, expecting a sharp rebuttal, but he whispers, "Stay calm. Courts don't like conflict." So you breathe deep, sip water, and watch the story harden. Mom is the anchor. Dad is the visitor. The children need stability, which apparently means less of you. That's the moment most men decide the system is rigged. Bias, they mutter. And yes, bias exists, but it feeds on unforced errors you were never warned about. You moved out too early, handed her the daily routine, ignored temporary orders because you thought they were temporary, trusted goodwill over documentation, and treated mediation like therapy instead of a chess match. The court didn't seize your leverage. You surrendered it, piece by polite piece. This video isn't about blaming you. It's about arming you. We're tearing apart the myths that hand her side the advantage before a single ruling and laying out a blueprint to flip the script. Because fairness in divorce court isn't a default setting. It's a prize you secure with strategy, evidence, and relentless follow-through. Get those three right, and even a tilted floor can be leveled. Family court starts every custody analysis with one question: who's already doing the work? Judges aren't sleuths. They scan calendars, daycare logs, and credibly presented stories to decide which parent supplies day-to-day stability. That's why the primary caregiver halo is so powerful. It frames mundane tasks, lunch packing, homework supervising, dentist scheduling, as proof of deeper attachment. When you moved out or took extra hours to cover 2 households, you left a vacuum she filled with routine. Now every morning drop-off she documents, every pediatrician visit she signs, becomes a glowing data point that says, "See, the kids orbit me." The halo intensifies when her lawyer bundles those tasks into a tidy timeline. Monday soccer, Tuesday piano, Wednesday tutoring, all handled by mom, while dad's name appears only on weekend game photos. The judge doesn't see the overtime paychecks that made those activities possible. He sees logistical parenting in technicolor and financial support as numbers on a spreadsheet. Worse, once the halo forms, it casts your involvement in shadow. Requests for equal time look like disruptions, not restorations. So how do you pierce it? Start before separation. Record every task you already handle. Screenshots of school app confirmations, receipts from grocery runs, timestamped photos of homework sessions. Log pickups and drop-offs in a shared calendar you can export later. If you're still under one roof, split mornings and document it. If living apart, insist on balanced overnights now, not after things settle. Submit your own timeline, visually with color-coded entries, to counter her narrative. A judge weighing 2 detailed caregiving charts sees parity, not halo. The burden then shifts to evidence, not assumptions, and the first tilt of the scales begins to level in your direction. The second the petition is filed, the clock starts on temporary orders, those supposedly provisional rules for custody, support, and who stays in the house while the case winds its way through court. Most dads shrug at the paperwork, thinking it's just for now. We'll hash out the real deal later. But family law insiders call these orders concrete in disguise, because judges hate to upend routines they themselves imposed. If the kids have lived 4 months under one residential schedule, the court sees continued stability, not a trial phase. Miss your chance to fight equal time at the temporary order hearing, and you'll be arguing against the judge's own precedent come final judgment. An uphill sprint in concrete shoes. Same with support numbers. They're calculated fast, often on incomplete income data, yet those figures morph into benchmarks. Deviating down later requires proof of drastic change, not just better math. Even possession of the house hardens. She remains in the home for continuity, and soon it's labeled the children's primary residence. The fix is front-loaded vigilance. The moment papers drop, demand a balanced schedule in writing, even if it means emergency mediation. Bring calendars, travel distances, school proximity, and propose a rotating plan that proves kids thrive in both homes. For support, supply thorough income docs for both parties and argue vocational assessments if she's underemployed. Do not let placeholder numbers codify lifestyle inflation. Finally, if you must leave the house, negotiate a use and occupancy agreement that credits your share of expenses against future equity. Treat temporary orders like the final draft they usually become, and you'll stop the status quo argument before it ever cements. Family court loves simple math, and nothing sounds simpler than he earns more, so he can afford more. That's the higher earner myth, an idea baked into countless support worksheets and whispered in mediation rooms. Your bigger paycheck means you can absorb a larger financial hit without harming your lifestyle, so why quibble over percentages? But the myth ignores context. Maybe you work 55 hours a week plus a brutal commute, sacrificing time to generate that income. Maybe her resume has been parked for years, not because she lacks skills, but because the household needed a parent on call, and you both agreed. Yet when the marriage folds, those past decisions get reframed as your personal advantage and her economic disadvantage. Courts rarely dig into whether she could re-enter the workforce at a competitive wage. They default to maintain the marital standard. Translation: your earning capacity becomes the family ATM, while her potential stays theoretical. The fix is proactive. Before the first support calculation, commission a vocational assessment that measures her current market value, degrees, certifications, and local job openings. Present that report with hard data on childcare costs, commuting time, and how a job shift would still allow balanced parenting. Show the court spreadsheets. With both incomes considered, each household maintains stability without you underwriting two lifestyles. And don't let luxury blips, big bonuses, overtime spikes inflate your baseline. Produce 3-year averages, document one-time payouts, and attach employer letters clarifying that extra money isn't guaranteed. Frame every dollar you earn as traded for hours away from the kids. The court must then weigh whether siphoning those dollars undermines the very stability it claims to protect. Break the myth early, and support transforms from open faucet to realistic sharing of responsibility, grounded in potential, not just past pay stubs. Walk into court fuming, and you've already lost the optics war. Judges are human. They scan body language long before they parse exhibits. If you interrupt, sigh, or roll your eyes when her attorney speaks, the bench subconsciously files you under hostile, a label that sticks tighter than any sworn affidavit. Meanwhile, she sits with folded hands, dabbing an occasional tear, speaking softly about the children's routines, and suddenly you're not just opposing parties. You're cast as volatility versus calm. It's swinging to the opposite extreme. Stone-faced silence hurts too. It makes you look disengaged, like custody and finances are logistical chores, not flesh and blood stakes. Emotional optics are a tightrope. Show controlled urgency, not raw anger. Display investment, not desperation. The secret is strategic channeling. Vent privately, never in the hallway outside chambers where court staff can overhear. If she makes a dramatic allegation, don't bite in open court. Note the claim, pass a discreet reminder to your attorney referencing the evidence that disproves it. Judges respect litigants who let paperwork, not pulse, do the talking. That means transforming frustration into timelines, screenshots, and calmly worded declarations. When the judge asks a question, keep answers under 30 seconds, cite a document, and stop. No anecdotes that spiral into emotion. Even outside the courtroom, curate your digital footprint. A single late night ran on social media can surface mid-trial as proof you're unable to co-parent civilly. Remember, she can cry without penalty, but you can't flare without consequence. Your best revenge against the bias of appearances is disciplined composure paired with unassailable evidence. Master that blend, and the court's subconscious tilt begins to flatten. Because predictability, not passion, is what judges ultimately trust. The fiercest battles are sometimes fought in filing cabinets. Whoever controls the paperwork controls the narrative, because in family court, events don't exist until they're stamped, filed, and hole-punched into the judge's binder. If she remained in the marital home, she also inherited the incoming mail, bank statements, tax notices, tuition invoices, medical bills, all addressed to the place you used to share. That stream of documents lets her attorney craft a curated history. Look, Your Honor, I pay the orthodontist, I handle insurance, I manage utilities, I buy groceries. Meanwhile, you're chasing duplicate statements through customer service phone trees, paying replacement copy fees, and praying the bank's notary gets forms back in time for discovery. Every gap lengthens the story she tells. Dad didn't provide receipts because he doesn't pay. Dad can't itemize pickups because he rarely shows. The judge sees her tidy exhibit binder in your stack of late-arriving PDFs and begins to equate organization with credibility. Take the power back. The moment separation is likely, switch every account to online delivery and two-factor authentication that pings your phone, not a shared email. Open a P.O. box or use a secure digital mailbox service so critical notices bypass the marital address entirely. For school and health portals, add your personal email, then screenshot each confirmation, date, time, IP address to prove equal access. Backup photos, coaching schedules, and expense logs to a cloud folder you can download in one click for your attorney. If she claims exclusivity over a pediatric file, subpoena it. Courts respect formal process over polite requests that go unanswered. And organize your evidence chronologically, color-coded tabs, succinct captions. When you walk into court with a binder as clean and complete as hers, the judge stops assuming one parent is the historian and the other is guessing. Control of documents shifts, and with it, the weight of credibility suddenly balanced because you stopped letting envelopes decide the story for you. Litigation fatigue is the silent opponent no one warns you about. An exhaustion measured not just in emotion, but in dollars bleeding from your account month after month. Double housing costs, discovery fees, vocational experts, guardian ad litem retainers, deposition transcripts. Every 90-day continuance inflates the bill, and the longer the process drags, the more you crave one thing: an ending. Opposing counsel knows this. They orchestrate delays like clockwork. A last-minute document dump forces your lawyer to request an extension. A sudden schedule conflict pushes mediation 3 weeks forward. A motion filed on Friday lands you with weekend rush fees. Each hiccup adds line items to your invoice and gnaws at your resolve until a lopsided offer starts to look like mercy. Meanwhile, your ex's household costs on mortgage payments you still cover or temporary support calculated before you started paying out of pocket for 2 residences and a legal team. When mediators say, "Let's be realistic, prolonging this will drain resources," they're reading from the script designed to break you. The fix isn't macho stamina. It's financial pre-strategy. Before the first filing, build a war chest. Sell a toy, tap a line of credit, or pause retirement contributions so litigation doesn't cannibalize rent money. Demand flat-fee billing on predictable tasks, drafting, discovery responses, so delays don't translate into open-ended hourly bleed. Establish a settlement threshold in writing with your attorney. The lowest acceptable custody split, the maximum support you'll concede. That document becomes your guardrail when exhaustion tempts you to sign away equity just to stop the hemorrhage. Schedule self-care like court dates, therapy, gym, nights offline, because fatigue thrives on isolation and insomnia. Remember, the other side isn't simply waiting for a judge. They're waiting for you to run out of steam. Budget, boundaries, and brutal honesty about your own limits transform endurance from guesswork into strategy, turning litigation fatigue from an unseen saboteur into just another factor you planned for and survived. Walk into mediation believing the neutral in the middle is truly neutral, and you'll walk out wondering why every compromise feels like capitulation. Mediators are human. Many are former family law attorneys steeped in the same cultural assumptions that already nudge courts toward a mother-centric default. Their mandate is to settle cases, not maximize fairness. And statistics show mothers are more likely to accept proposals that preserve primary custody while giving up pieces of money. So nudging you to concede parenting time greases the gears of resolution. Listen closely and you'll hear the bias in soft language. Maybe let mom keep school nights so homework stays consistent. Or kids need one home base. Dad can get quality time on weekends. Each suggestion reframes your equal parent vision as disruption, your insistence on specifics as stubbornness. The longer you resist, the more the mediator warns of mounting fees and the judge's unpredictable hammer. Pressure that conveniently mirrors your ex's narrative. You can tilt the room back. Don't arrive empty-handed. Come with a detailed, color-coded parenting plan that already builds stability. Identical bedtimes, shared Google Calendar, split homework supervision, transportation logistics mapped. A concrete blueprint forces the mediator to evaluate your structure, not her abstract fears. Bring child development studies showing equal overnights foster academic and emotional resilience. Quoting research shifts the conversation from feelings to data. Insist all proposals be typed and time-stamped on the spot. No verbal nudges, so concessions don't morph later. Finally, track mediator language. If suggestions repeatedly steer custodial weight to her, politely request they articulate the statutory basis for that imbalance. Most can't, and the question alone recalibrates the power dynamic. When neutrality is a myth, evidence, preparation, and procedural accountability make bias visible. And once bias is visible, it loses much of its force. All the theory means nothing if you don't translate it into a clock-ticking action plan. Think of the next 90 days as the window where leverage is won or squandered. Day 1 to 7. Launch a documentation blitz. Photograph every morning routine. Save every pickup drop-off text. Scan receipts for groceries, school supplies, doctor copays. Open a cloud folder and label it by category: custody, finances, communication, so your attorney could drag and drop exhibits instead of drowning in email chains. Day 8 to 14. Lock in temporary orders. File an emergency motion, if needed, demanding a balanced schedule and explicit language blocking relocation. Put equal time in writing now, or watch weekends become your ceiling later. Day 15 to 21. Order a vocational assessment on your ex and a 3-year income average on yourself. Get ahead of inflated support numbers before they calcify. Day 22 to 30. Centralize money. Switch every bank, credit card, and utility to paperless with 2-factor authentication. Pull 6 months of statements and hand them to your lawyer before discovery even starts. Day 31 to 45. Set up weekly strategy calls. 15 minutes. Agenda emailed the day prior. Summary emailed afterward. If your lawyer can't commit, shop for one who can. Mid-case switches are painful, but cheaper than a lifetime of regret. Day 46 to 60. Draft your own parenting plan, color-coded calendar, transportation matrix, conflict resolution clause, and practice presenting it in 5 minutes flat, because mediators reward clarity. Day 61 to 75. Pre-budget trial costs, mediation fees, and a 6-month cushion of dual housing expenses. Knowing the burn rate inoculates you against settlement panic. Day 76 to 90. Rehearse court demeanor on video. Monitor tone, posture, eye contact until composure is habit, not performance. Upload the clip to that same evidence folder. It reminds you how far you've come and proves to your own lawyer you're ready for the stand. 90 days of methodical moves won't erase every bias, but they'll replace courtroom guesswork with a paper fortress. And judges trust the parent who arrives armed with facts, solutions, and unshakable calm. The idea that divorce court automatically tilts against men is only half the story. The other half is the steady drip of leverage we volunteer. By assuming fairness, moving out too soon, agreeing to temporary orders that harden into final ones, mistaking bigger paychecks for bottomless wallets, cracking under litigation fatigue, or trusting that a mediator will champion neutrality. Bias certainly exists, but bias feeds on gaps we leave open and narratives we allow others to craft. Close those gaps and the tilt flattens. Become the parent who documents, not reminisces, caregiving. Treat interim hearings like final trials because, in effect, they are. Produce vocational evidence that her potential income matches the modern labor market. Channel frustration into concise filings and rock-solid court demeanor that earns judicial trust. Seize control of paperwork by rerouting mail, digitizing records, and subpoenaing any document she withholds. Budget like a general stockpiling rations for a siege, so you won't surrender equity just to stop the clock. Enter mediation armed with a polished parenting blueprint and research that reframes equal time as stability, not disruption. And anchor it all in a 90-day plan that turns overwhelm into a checklist of wins. Records gathered, orders balanced, strategies rehearsed. Courts rule on evidence, patterns, and perceived reliability. When you master those three, the scales stop favoring one side and start favoring whoever is better prepared. So don't walk into the arena muttering about bias and hoping for mercy. Walk in holding folders so organized they make the judge's job easy, a demeanor so steady it defuses stereotypes, and a strategy so proactive it forces everyone in the room, including opposing counsel, to treat you not as the underdog, but as the parent who came to fight smart, fight fair, and refuse surrender. Because in family court, fairness isn't gifted, it's engineered, and now you have the blueprint.